This is the second time that you're kind of getting away with doing something that you probably shouldn't. This no contact order is going to include literally looking that direction. If you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail, to find you guilty, and at this time find you guilty of driving while intoxicated, third or more, sentence you in accordance with your agreement to a term of 10 years. So on these new offenses, the possession of a firearm allegation, is that something that only that uncooperating witness could prove up, or is that something that law enforcement?
There was a question about whose weapon it was.
Because this is the second MTRP that has to do with.
Well, the first one was dismissed because the only allegation was that he possessed a firearm and fell in possession of a firearm, and he had been on deferred, so he wasn't.
Right. But still shouldn't be possessing a firearm while you're on probation, regardless of that. So, Mr. Reddo, probably what's going to happen today, based on the information that I've received from the district attorney's office, is that that motion to revoke your probation is going to be dismissed. This is the second time that you're kind of getting away with doing something that you probably shouldn't. I want you to understand at this point, I'm going to order that you are on zero tolerance on your probation, that you will be on the high medium caseload and required to do everything that you're supposed to be doing. If you are caught with a firearm, if you're around anyone with a firearm, I don't care who it belongs to, ownership, if you're around it, it is going to be a violation of your probation. I'm ordering a condition of your probation is that you are not allowed to be around or in possession of a firearm in any way, not in the same house as one, not in the same car as one, period, none. So there won't be any question if there's an issue that keeps popping up here with regard to firearms, that if you're around one, it won't matter whose it was or whose it belongs to. It's going to be a violation, and it's not going to get dismissed. You're going to end up going to prison. Do you understand? You're on a very serious probation, and I have some concerns about what's going on. But you're back on that probation. You still have the same opportunity to be successful. It's going to be up to you to quit doing whatever it is that's going on. Okay. If you have an issue with whoever it is that you're dating or married, then you need to get away from that, because that's going to end up getting you into trouble. Right. Okay. You can go back with the bailiff. Good morning, sir. You're Dan Church.
Oh, yes, ma'am.
And this is 26 DCCR 0612. Mr. Church is charged with deadly conduct, discharging a firearm. And the state has filed a motion asking that I'm looking at the state's motion. The motion it says aggravated assault, but the charge is deadly conduct. That just
I'm sorry, Judge. That's my error. I was trying to file it rather quickly after receiving the affidavit from the complainant. I'll fill the court in on that as to why I don't have a witness present.
Looks like the current bond is set at $20,000. The state has asked to raise that bond. Ms. Malfino?
Excuse me, Judge, and I apologize about that error. Obviously, the court would see the probable cause affidavit is very similar to an aggravated assault, discharging a weapon somewhat in the direction of the complainant. In this case, I have had multiple conversations with Jeremy Shelton, the complainant. He is the across the street neighbor of Mr. Church. He is a very nice young man. He was very forthright, came in and presented me or had an affidavit authored by himself with one of my investigators in lieu of coming to docket today. He, as the court can probably surmise, is of the mind that he doesn't want to aggravate the situation. Nope, not intending to use that same word, but I will tender that as State's Exhibit number 1 just for purposes of this hearing. And I have Mr. Gertz, it's his affidavit just expressing concern about the nature of this offense and the fact that they reside across the street from one another, that he has a very young son and a wife who were also present at the time of this offense. And he is concerned that Mr. Church may be keeping weapons at his sister's house down the street. I have worked very closely with my investigator, Mr. Bays, and he is familiar with Mr. Church as well as Port Arthur Police Department is. And we've asked that some things be implemented in the interim time period to hopefully assure the safety of all the parties, including Mr. Church. I just wanted to bring this matter to the court's attention with that motion. It's not necessarily intended to increase as much as it is to modify with the admonishment regarding weapons, etc., because obviously it's difficult to remove these two individuals from one another approximately because of where they both reside.
Any objection to me reviewing that?
Well, Judge, the rules of evidence don't apply in a bond hearing, so I would love to have some great evidence, but I don't have a good one.
And I'll state the ones admitted for purposes of this hearing. Give me just a second, please. Mr. Gertz?
Judge, I'm happy to discuss bond conditions. $20,000 is more than sufficient, though, in terms of amount for this allegation as it stands right now, or as it's indicted right now. Mr. Church wouldn't, I think, object to the normal conditions of not having any contact with the complainant, not possessing any weapons.
Those are already conditions.
Right. I'm not sure what else. What else the court could impose because of the proximity of their homes without infringing on his constitutional property rights of his own. But I think the fact that he's hired counsel, has shown up to court, he's taken this seriously. He's not been threatening the complainant or anything of that nature. I understand the complainant may have concerns, but those are the complainant's concerns. They're not being triggered by anything, no pun intended, by anything that Mr. Church has done since his arrest or his indictment. And so, and he's not violated any of his bond conditions that
No, I think
that I'm aware of, or that
is if they feel like he is watching, could be, just uncomfortable. There's an allegation that he's sitting in his car watching family, obviously based on the nature of the offense and the allegations and the probable cause. That would give me some concern too if I had lived across the street and that had actually happened. So,
but I don't think I just don't think raising his bond and just charging him more penalty is the proper remedy for that. So I'm not sure how the court remedies that. And I don't see what
the way it gets remedied, Mr. Church, is if you're doing anything that's making the person uncomfortable, that's the complaining witness in this case, the only way for me to take care of that is to put you in jail. Then they don't have to, nobody has to worry. I don't want to do that, but I need you to understand that there's no way around if, you're not contacting them or talking to them. I get that. But if you're doing other things, like sitting in your car and watching them, then that's going to be of concern to me. So I'm ordering you. Here's what I'm ordering right now. Listen to what I'm going to say very clearly, okay? This no contact order is going to include literally looking that direction. You can't sit on your front porch. You need to sit in the back. You can't just sit in your car for no good reason. People don't do that. So you're not going to do that. Do you understand? So if they feel uncomfortable, they're going to let Ms. Malfino know and you're going to end up in jail. So I understand you live across the street, but if I were you, I'd walk. If I was going out my front door, get in your car and leave if you're going somewhere. No lingering, no looking that direction, no standing there watching. Otherwise, you're going to end up in jail because I won't have any other choice. Does that make sense? Okay. So we'll reset this for an announcement. Make sure you stay in touch with Mr. Gertz, visit with him before that next court date, and we'll see if we can get an announcement, okay? You're free to go. Oh, you're up. Good morning, sir. Are you Daniel Ward?
Yes, ma'am.
And Mr. Ward was previously in court and cause number 25 DCCR 1375, entered a plea of guilty to driving while intoxicated, third or more. I've received that pre-sentence report. If you both had an opportunity to review that report.
Yes, ma'am.
Nichols,
Yes, Your Honor.
any additions or corrections?
The only thing I would add to it is they've determined to be a moderate to severe risk. The issue that I have with that is that the bulk of his criminal conduct is 21 years ago
Right.
and 24 years ago. The last DWI that he had was 13 years ago. And what I would ask Judge is simply, I don't take away from what his history shows, but being that it's been 13 years before he's had any issues with drinking whatsoever. If the court is inclined to move forward with the JCDI program and various programs, I would simply ask maybe the court consider ordering it, but holding it in abeyance. And if he has any issue, any hiccup whatsoever while he's on probation, then implement that. But 13 years is a pretty good amount of time.
Well, I agree with you on that. The issue that I've got really is from that substance abuse assessment, which doesn't really have anything to do with the length of time or what the history is. It's just what's going on now and what their determination was. And their determination was severe alcohol use disorder as well as severe sedative disorder. And I think to make sure that he is successful, I am inclined to order what they have requested so that
And
we don't have any
And
issues.
if I may, to say, I think I've always said the best indicator of future behavior is when you've done 13 years is an incredibly long time to go for anybody. So at the end of the day,
Well, how long have you gone?
I've gone for 61 years, Judge.
Right.
But at the end of the day, but for the grace of God goes I. And
Same here.
so anyway, whatever the court's wisdom, the only other
Thank you.
thing
I
would
appreciate
ask,
that.
Judge, he does have to do 10 days as a condition.
Yes.
He's full-time employed.
Okay.
We have asked that he do it on
Yeah,
weekends.
no problem with that.
No issue.
So, any issue with starting this weekend? It would be from Friday. You'll go in Friday at 6. They'll let you out on Sunday and you'll do that.
I mean, if you can do it, great. If not, she just needs to know a date.
Can I have like a 2-week notice, like not this weekend, but the following?
Are you working this weekend?
Yes, ma'am.
Okay, so here's what I'll do, Mr. Ward. I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty, and at this time, find you guilty of driving while intoxicated, third or more. Sentence you in accordance with your agreement to a term of 10 years in the institutional division of the Texas Department of Corrections, but I'm going to suspend that. Place you on probation for 5 years. You're ordered to follow all of the rules and conditions of probation. That includes paying a $500 fine. You will be ordered to serve the 10 days upfront time, and I will do some dates on that in just a second. Also, I am going to order that you enter and successfully complete that JCDI program. I understand and respect what your attorney's asking for, but just based on the information that I have, I think it's important that you have those tools up front so that this doesn't ever happen again in 1 year or however many years. All right.
Yeah.
So you will be ordered to complete that program. If you do everything that you're supposed to when you're on this probation, this is a great opportunity because you'll be able to serve that sentence while you're out on probation. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be facing that 10-year sentence in prison that you've already agreed to. Do you understand? So we're going to start your weekends on June 19th. So that's a week from this Friday. And you'll go in Friday at 6 o'clock to the Jefferson County Jail. It's important that you're on time. If you're late, you can be considered a no-show. Obviously, if you don't show, it's a violation of your probation. It's very important that you don't. Some people think, and I know this isn't going to be you, that if they show up intoxicated, they're going to sleep it off for the weekend. Please don't do that. That's obviously a violation of your probation. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney, okay? You need to have a seat here in the courtroom. Probation is going to call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you.